Hello, viewers. I'll speak today about recent development on EU law in relation to Brexit. I'll speak about how it will impact life of EU citizen who is living in the UK or their EU family members. My name is Suhail Ahmed. If you have any question, please feel free to leave a comment below my live video, or you can call me at the number appear on the screen. So let's start with the deadline for Brexit. Everyone know about the deadline for Brexit, that is 31st December 2020. Does it mean that if any EU citizen who will come to the UK before Brexit, I mean before 31st of December 2020, can continuously live in the UK? This is not actually a stage we answer that yes. If any EU citizen come before 31st December 2020, and if he want to continue living in the UK after Brexit, he must exercise EU treaty rights. That is, he has to be a qualified person under EU law. Under Regulation 6 of EU law, any person, any EU national who is a worker or self-employed people, they are and some other category of around 5 types of people who are a qualified person. So if someone come before 31st December 2020 and start work, then that person can continue to live in the UK after 31st December 2020. The second issue is the deadline for application for pre-settle or settled status is. So many of people know that the deadline for Brexit application under EU settlement scheme to continue to live after Brexit is 31st December 2020. This is not the case. The deadline for application under EU settlement scheme is June 2021. So after Brexit, still EU nationals and their family member will get 6 more months to make application under EU settlement scheme. However, it is advisable to make application before 31st December 2020 if anyone wants to continue to live after Brexit. If you don't make the application, unfortunately, after Brexit, it will be very difficult to continue to get access to public funds or NHS treatment, or continue to even continue your job. With regard to EU family members, where many people also don't have this information, that EU nationals who will come to the UK before Brexit, I mean before 31st December 2020, and if they exercise treaty right before Brexit 31st December 2020, they will able to invite their non-EU family member even after Brexit, means from 31st December 2020 to further 5 years, which is 31st December 2025. So some people are rushing to make application to inviting their non-EU family member or extended family member, but it is not necessary if your document is not ready, if your payslip is not ready, if your bank statement is not ready, if you don't have accommodation arrangement, you don't need to rush to make an application before Brexit, because for your EU family member, you can apply further 5 years from point of Brexit. But the condition is you must be a qualified person before Brexit, before 31st December 2020. At the same time, your relationship with non-EU family member should start prior to 31st December 2020. And your relationship should continue until you make the application. If you satisfy all these basic requirements, you can invite your non-EU family member to come to the UK after Brexit, means after 31st December 2022 to 31st December 2025. The requirement and eligibility is same as under EU Regulation 2016. Before 31st December 2020, you have an option to make the application under EU law, or you have option to make the application under EU settlement scheme. But after 31st December 2020, you will have only option to make the application under EU settlement scheme, because after 31st December 2020, there will be no more EU law applicable to the UK. Therefore, where there is no law, you cannot exercise EU rights, because if you don't have the law, you will not have any right under this law. So to replace this EU regulation, to keep free movement of EU family members, the UK government introduced EU settlement scheme. So after Brexit, the rights of EU citizens, the rights of EU family members will deal by EU settlement scheme. So this piece of legislation is very important for EU citizen and their family member. It is not an arrangement for transitional arrangement for for pre-settle or settled application, but it will be a great impact. It will be the sole law after Brexit. Now, the extended family member again can also come to the UK under the EU settlement scheme, subject to fulfill all the same requirement which is under Brexit, under the EU settlement scheme. Basically, section EU regulation 8, EU regulation 7 is a replacement by the EU settlement scheme. All the requirement is same. I'll explain you after a short break how you can apply and what are the requirements to invite your extended family member to come to the UK. So, for EU family member, is very familiar under the EU regulation 7, that is your spouse, your children, your parents, dependent parents, they are EU family member. This is a very straightforward application. You can make an application for leave to enter under under EU settlement scheme, which is pre-settle status, pre-settle for leave to enter. If you want to make application under EU settlement scheme, pre-settle. If you want to make application under EU regulation, that is EU family permit. But it is advisable to make the application under EU settlement scheme. Many people doing a very basic mistakes right now, even for the EU family member residence card, they're making application under EU law, and Home Office are issuing only 7-month visa, 8-month visa, just up to June 2021. In that case, they should get 5 years visa, and they are coming back to the solicitor and asking why I get 9-month visa. Exactly, I received a message today that I applied for EU visa, but I got only 7, 8-month or 9-month visa. The reason is you make an application under EU law, because if you make an application under EU regulation 2016, you will get visa up to June 2021. Because after June 2021, there will be no EU law. Therefore, Home Office issuing visa under EU law, and so up to June 2021. What you should do, or what you're supposed to do, is you should make an application under EU settlement scheme. If you could make application under EU settlement scheme, you should get visa for 5 years. That is a pre-settled status for 5 years. Many people also doing the same mistake on permanent residence. Some people, instead of making application for EU settled status, they are making application still for permanent resident under EU regulation 2016. This is also a basic mistake. You shouldn't make application under EU regulation right now for permanent residence. Permanent resident under EU regulation 2016, it doesn't mean it is a permanent resident. Now, because when there will be no law, there will be no value for permanent residence. So you shouldn't make application under regulation 2016. Rather than you should make application under EU settlement scheme. Because if you make an application under EU settlement scheme, you'll get visa for 10 years. And if you make an application for permanent residence under EU regulation, you will get visa for only 9 months up to June. So that is what the difference is. So that is what is one point. The second point is I want to discuss about under the new arrangement for international student from 5th of October, if any student want to come to the UK from Europe for study in UK university, they will subject to under new immigration rules for Tier 4 student. That is from 5th of October, any EU student, if they want to come to the UK, they will be required to pay tuition fee to the university. They will be required to pay the NHS fee, which is immigration health surcharge, which is going to be £1,530 from next month. It's supposed to start from 1st of October, but it will be start now from 15th October. Immigration health surcharge, which is going to be £600, more than £600 from next month. So if anyone want to make an application for leave to remain in the UK, I will advise you, if your visa expire after 28 days, you should make application as soon as possible. I mean before 15th of October, because if you make the application before 15th of October, you will save some money from paying the NHS fee. Viewers, I'll back again about EU law, but I'll take some question from Facebook. If you have any question, please leave a comment and I'll try to give you answer. Thank you very much. Journal Khan, you write me an answer, details address. Unfortunately, you shouldn't write your personal address here. So I'll not read the details. So next discussion about EU extended family member. Recently, a lot of applications are refusing by the Home Office for a EU extended family member, and the reason is just lack of evidence, because everyone in last minute they want to bring their family member, their parents, their relatives who is dependent on them, and they're presuming that in December will be the last date of application, and they're making application on rush and they cannot prepare all the necessary document. Extended family member is very wide. Definition of extended family member is very wide, but Home Office is very strict with the requirement, because an EU nationals can apply for leave to enter for anyone, any relatives, if he can prove that they are financially dependent. Now, to prove that financially dependent, this is the main reason Home Office refused, because Home Office want to very strictly satisfy this requirement. Now, what you have to satisfy that your relatives, whoever is dependent on you, they are financially dependent on you. Now, if you just prove and provide evidence that a couple of money receipt and couple of bank statement or your present, this is not sufficient. You have to provide evidence that that relatives is 100% financially dependent on you. So, for example, if you invite someone from Bangladesh, then what is the living allowance, or what is the living, how much cost for someone in Bangladesh to live? So, for example, if it is £50 or £100 enough a month, you should give that amount of money. That will give you an impression that that person is financially dependent on you. In addition to that, I will give you information of what specific document you should give with the evidence. Stay with me. So, in terms of extended family member, is I said under Regulation 8, anyone can be a relative who is financially dependent on you, is extended family member. Extended family member, if you want to bring under EU law, you must prove that the person is financially dependent on you. So to prove that the person is financially dependent, you need to provide last 6 month money receipt that you send them money in every month or every week, or whatever, how the way you send them. So first requirement is money receipt, and you should send that amount of money what they need to live in a country. For example, if you pay them just £20 every month or every week, and if that money is not sufficient to live in that country, this will not satisfy the requirement. So you need to, this is a question which is very difficult even to prove. However, you should use your country resources. You should use any example or any survey report that how much money need to someone to live in your home country. Any reference with the government plan or any organization reference, and you should send that amount of money what they need to live on their home country. For example, what I say that if someone needs 10,000 rupee or 10,000 taka in their home country, you should send £100 every month. You need to prove that they are fully financially dependent on you. If they have any income on their home country, in that case, they are not financially dependent. So you have to be very careful with the financial dependency requirement. For example, if someone receives pension or any rent or any kinds of income, then you cannot claim that a person is financially dependent on you. Now, in the Home Office policy guidelines, the requirement is you need to provide 6-month payslip. One requirement, you need to provide 6-month bank statement from yourself that you will show that you are sending money each month from your account or every week. You should give a bank statement from the applicant as well that will show that she or he is receiving money from you in every week or every month. So you need to give both bank statement. Many people send money from a high street money transfer in a cash point. They just give the cash money and the applicant receive only cash as well. I think this is not a good idea. My advice will be you should send money from your bank account to the applicant bank account. This will give you a solid evidence that the applicant is financially dependent on you. In addition to the bank statement, the money received, you should also give some countries, some bank give a collection slip, because I saw in a refusal letter in many applicants, the Home Office raised this issue that you didn't give us the collection receipt. So the way you give money received to the Home Office with the supporting document, you should give also the collection receipt, because when someone receives money from bank or from any agency, they normally give a collection receipt. So you need to give money receipt from your side and your bank statement, and from the applicant should give collection receipt as well as their bank statement. So these two full evidence is mandatory to prove someone is financially dependent on you. The second requirement, I said you should give that amount of money what they need to survive in their home country. So it's not necessary that you have to give £500 or £500, £400. You should give that amount of money what is reasonable to pay their household cost, their bills, their rent. Final evidence is tenancy agreement. Now, if you have any opportunity to or any option that to rent a home over there, so the Home Office guidelines said yes, you can give a proof of tenancy agreement or accommodation arrangement in your home country where they're living. So if you rent a room over there, you can provide a tenancy agreement. That is that you rent this house and you pay the rent every month, or you pay the money to them and they pay rent. The tenancy is in your agreement. So you can provide that evidence as well. In addition to that, if you have any utility bills in together, or if you lived with them in previously, so if any utility bills come in your joint name, it is a good idea to give the tenancy agreement some utility. I know in many countries they don't have any utility bills like in the UK, but if you have any option, many countries have this utility bills, electricity bills, or some joint bank statement come to the same address. So these types of evidence you can use to show that they are financially dependent on you, and they're living on your home. So this is what finance, because the main requirement of uh, extended family member is financial dependency. Now, from your side, I said you have to be a qualified person. This is a mandatory for you. So if you are EU nationals, in UK, there are food where you can become a qualified person, but most of them are a worker. So if you are a worker, you need to provide evidence of your payslip, employment letter from employer. You can provide again the bank statement, which will show you that you earn money every month or every week, your salary coming to your bank statement. Now, many people also have a confusion that they are in receipt of public funds. Whether receipt of public fund is a disqualification, or will it impact to invite your family member in the UK? That is very important. The straightway answer is receipt of public funds is not a disqualification. I have recently dealt with the same case, and one of my clients invited her mother, and Home Office refused on the basis of public funds. But I went to the First Tribunal, and I gave my submission, and the First Tribunal accept my submission and give an order to issue visa under EU law. So if you are in receipt of public funds, still you can invite your family member, but most probably Home Office may be refused on the ground that you are already burdened for the taxpayer, and if you bring your family member, they will be burdened as well. But remember, if you go to the court, I hope you will win the case. So a receipt of public funds is not a disqualification. You can still exercise your rights, and you can invite your family as soon as you want. Now, how much you have to earn to become a qualified person? This is the old question, but I'll give again. Many people are facing same problem. The immigration rules requirement is that job should be an effective, genuine and effective employment. That's what is the requirement. In a case, so there is no definition of who is a worker, whether someone has to work full-time or part-time. EU law didn't explain this answer. However, there is a case law which is came from the Strasbourg Code, that is anyone who even work part-time is a worker. And then later on, the same case deal by the European Court of Justice, that anyone, even someone work for 10 hours, he is still a worker. However, in UK immigration law, the requirement is your job has to be a genuine and effective employment. Now, genuine and effective employment means if you pay class 1 national insurance, that is your employment is genuine and effective employment. The current requirement is if anyone earn £972 per month, that employment is effective employment under immigration law, and you can apply and invite your family member or extended family member to come to the UK. So this is what the requirement is. Viewers, I spoke about the impact of new recent development on EU law. The recent most important development is a student visa for EU nationals. If any EU nationals or EU student want to come to study in the UK, they will be required to pay tuition fee, and this is the new development from last 35 years. After UK become the member of EU, European Union, EU student can come to the UK and get finance from student loan. They don't need to pay any tuition fee. They don't need to pay any fee for NHS. Although they are required normally to buy comprehensive sickness insurance. Another recent development is, although it was an old rules, however, Home Office never exercise or bring this issue in refusal. When any EU nationals apply for a British nationality or for naturalization, now Home Office is asking whether there was any time student in the UK, whether they were self-sufficient or self-employed in previously any time in the UK. And the answer is, if you are self-employed or self-sufficient person, or if you are in student, then the general requirement of EU law is you should have comprehensive sickness insurance. But many people, many EU students, they know. So far, I know I didn't find anyone who bought a comprehensive sickness insurance. Unfortunately, right now, Home Office are refusing those nationalization application on the ground that you don't have a comprehensive sickness insurance. So this is an issue which actually started recently. That is, Home Office refusing a naturalization application for EU nationals, big lack of comprehensive sickness insurance. Now, comprehensive sickness insurance basically need only a EU student and self-sufficient person. So these two group of people need comprehensive sickness insurance. Unfortunately, many non-EU family member who was student in the UK, the Home Office also refusing their naturalization application on the ground lack of comprehensive sickness insurance. But if the rule is that EU law is, if you are a non-EU family member, although you are a student in the UK, you don't need comprehensive sickness insurance if your family member, means if you EU nationals, was a qualified person, means was a worker. So if your partner or if your wife or your husband work in the UK, and if he pay national insurance contribution or pay that tax, in that case that you don't need comprehensive sickness insurance. So when you make an application, the general this question will come to the your when you submit the application, but you should write a cover letter that I was student, but I was a family member of a worker. My partner or my husband or my wife was a worker in the UK, therefore I'm not required to satisfy the requirement of comprehensive sickness insurance. In that case, the Home Office caseworker should issue you a naturalization certificate. However, those students or those people, those EU nationals who was a self-sufficient person in the UK, you should have a comprehensive sickness insurance. If you don't have, unfortunately, probably you will be face a refusal of your naturalization application. And in that case, it is advisable you should speak to any solicitor before you make this application, explaining your situation. Viewers, thank you very much. This was all about for EU law today. And I again sum up the recent development and the time limit or deadline for EU law, EU family member application, free movement of EU nationals, and free movement of non-EU family member. I'll come back and I'll sum up the details in a minute. So the time limit or deadline for free movement of EU family member is 31st December 2025 if your EU national satisfied three requirements. First is he was a qualified person, he exercised TT rights before 31st December 2020. That means you move to the UK, you come to the UK before 31st December 2020, and you will exercise EU TT rights. So you become a qualified person before Brexit. The second requirement is your relationship with your non-EU family member or extended family member has started prior to 31st December 2021. The third requirement is your relationship must continue with non-EU family member until you make the application. If you satisfy this requirement, you can bring your EU family member or extended family member under EU settlement scheme after Brexit to till 31st December 2025. If you cannot satisfy the requirement, you can still invite your family member to come to the UK under UK immigration law. In that case, the general requirement is you can invite your family member, means your spouse, your children under 18. You can invite them under UK immigration law, satisfy the requirement that you earn £18,600. In addition to, if you have any child, you need to earn for the first child £3,800, and from the second child and onward, you should earn 2,400 additional income. So if you satisfy this requirement, accommodation requirement, English language requirement, relationship requirement, is very difficult for many people to satisfy all the requirements. So this is what all about for a non-EU family member to come to the UK. Now, for Brexit deadline for free movement for EU national is 31st December 2020. If you want to come to the UK, you have to come before that time, and you have to exercise TD right. You have to be a qualified person from that deadline. If you just travel to the UK before 31st December 2021, you might not be able to secure your pre-settled status. So you should come before 31st December, and you should exercise TD right, that you should start work. You have to be a qualified person. Many people can apply from are applying as well from outside the UK for pre-settled status under the EU settlement scheme. Yes, legally you can make an application. Unfortunately, if you don't come before 31st December 2020, then you will not able to enter after that. So you should come before that time, the deadline, and exercise till that means you should start work. The deadline for EU settlement application is December 30 June 2021. After that, no one will able to make any application under EU settlement scheme. So you have to apply before that deadline. If you don't make the application, you will face very serious consequence. That is including you could face refusal. You could face no access to public funds. You will be required to pay NHS services. You'll be required to satisfy in bank. You'll face a problem in bank. Maybe bank will ask you to give your immigration paperwork. Maybe your employer will ask you to give your immigration status. So this question will come to you after Brexit. So today I saw a newspaper, news in Guardian, that many people still even doesn't know about EU settlement application, and I'm presuming that will be a issue like Windrush generation scandal. That is, many people came in this country that didn't apply, or somehow they don't care about it, or Home Office refused their application and they didn't appeal, and later they face deportation unfairly and unfortunately. They live here a long time, but they still face the deportation. The same something will be happen. So it's not something that you can neglect, because I know EU people, EU national citizen, came in this country very easily. They don't have to satisfy any requirement, and they don't give importance. But it is important, if you want to live here in the UK continuously, it is advisable you should make an application as soon as possible. Mr. Ali, any idea when will super priority service open? Brother, I don't have any idea right now, but most probably it will be delayed again, because we are expecting that after November it will start it, but due to the COVID, which is the affection, the new lockdown is on the way, so it will be more late. So probably after 6 months, we are expecting some form of premium service. You asked me very long question. I think I'll not read your question on live. If you kindly send me this email, then I'll give you a reply. Everyone, good night. Thank you to come to my live program and watch or give and share. I'll see you again tomorrow with a new update. Bye for tonight.